We're very happy to be here today to be organizing this initiative. We see our venue, our presentation center, as in an area of exchange, of dialogue.
I wanted you to welcome Shirley, who's going to talk about assignment today. Thank you.
Hi, everyone. Thank you for joining us this afternoon. I hope you've had a good lunch and are ready for my talk this afternoon. I'd like to personally thank Concord, Jerome, Isaac, CREPSO directors for making this possible. Now, we will be speaking on or discussing issues dealing with an assignment. More specifically, pre-construction assignments. Now, we will have basically a discussion on 6 topics. Briefly, what is an assignment? Maybe some of you only heard of an assignment, but have never really encountered the problems associated with putting a good assignment together. We're going to talk about the issues facing the assignor and the assignee. Now, I'm just going to go back to basics. An assigner represents the original buyer of the agreement of purchase and sale, and the assignee is the ultimate purchaser. Okay, so don't get these terms mixed up. Assignor is the original purchaser, the assignee is the new purchaser. We're also going to talk about the issue of tenants. Let's say we have an assignment, we have an assignment closing. What happens when there are tenants involved? Also, I'm going to talk a little bit about how do you put together a good assignment agreement. Obviously, we're limited by time today, so I'll just pick on some of the relevant issues. And also, most importantly, if you don't take away anything from today's talk, please take away the area regarding the HST implications of an assignment agreement. So some of these issues may be new issues, some of these issues may be old issues for a lot of you, but the relevant issue today is dealing with the HST implications. And lastly, I will touch briefly upon the income tax implications of an assignment transactions, especially for the assignor. All right, let's start. What is an assignment? Basically, an assignment is an individual selling their contract. Back in the good old days, we called this flipping. Remember that? Way, way back. We don't use the term flipping anymore. We use the term assignment because basically we are selling a contract which has not closed yet. And once we assign a contract, all the rights and obligations of the original purchaser is assigned to the new purchaser, the assignee. Although we are focusing today on the condominium, the assignment basically applies to almost any agreement of purchase and sale, freeholds. So it's not limited just to pre-construction agreements. Now, I'm going to tell you a few things that no one has told you about assignments. Assignments basically are complicated transactions. They really are. It's almost a specialty. Some agents do a lot. Some agents have never encountered one before. Whether you have done one before or not, or are very experienced, what I'm going to talk about today will hopefully bring you up to date as to what is new and relevant right now. Now, another thing about assignments is that they're not easy to market, all right? A lot of agreement and purchase of sales, they have restrictions in the agreement limiting marketing. So oftentimes you will not see an assignment marketed on MLS or the newspaper or on Craigslist. Oftentimes you have to sell an assignment by word of mouth, and that may be difficult. And because of this, we may come into a value issue because the particular unit is not marketed. So how do you actually know what is the current market value of the unit that you are trying to sell? And believe it or not, most builders don't like dealing with assignments. And I don't blame them. Extra work. In effect, they're almost like selling a unit twice all over. Fourthly, no financing is available for the assignee. So if you have an assignee who has limited funds, then be very careful. They may or may not be in a position to entertain an assignment. And I'll explain to you why as we move on. Now, tax consequences, all right? I think few of us have addressed this issue. I think all the other issues we would have thought of previously, but right now, the big thing is in connection to CRA and how they are targeting assignments. Now, lastly, most agents and lawyers and also their support staff may or may not have the expertise or familiarity with dealing with assignments. So these are the few things that a lot of people don't know. Now, notwithstanding, why are assignments still so popular? All right? It's almost become part of the regular transactions that we do on a daily basis. Well, a few things. Condos are still perceived to be more affordable, all right? There's still a great demand for housing, population growth, supply and demand issues. Most condos are located in great locations, okay? Usually along subway lines, and we all want to eliminate the time for traveling, and therefore location trumps all. A lot of individuals are also tempted by or enticed by living in brand new buildings. And also, it's almost a second kick of the can, because a lot of these buildings, previously when they were initially marketed, are now sold out. So here's your second chance of perhaps living in a choice building that you've always had your eye on. Now, once we've concluded that you want to assign, here are some of the reasons why perhaps you would want to. First of all, change in circumstances. So the original buyer, something have changed. And again, I'll talk about that as we move on. Now, maybe the original buyer, with all of the new restrictions with respect to mortgaging and the new stress tests, they may not qualify for a mortgage anymore. So they may not be able to close on the original agreement. Now, also, the value of a lot of condos have increased significantly over the years. And the original buyer may just want to cash out. Or the original buyer just needs money for something else. And maybe the original buyer already has a ready purchaser for that particular unit without the necessity of having to market it. Now, if you are the assignor, so you have concluded you want to sell your contract, what are your considerations? Most importantly, you have to read your original agreement of purchases and sale. I know a lot of agents are daunted by reading 30 or 40 pages. But unfortunately, if you want to assist your client in marketing this particular unit, you have to read the agreement to see whether the agreement allows for an assignment. And not all agreements allow for that. Now, let's say your client's agreement does indeed allow for an assignment. Then you have to see what are the conditions. There are certain conditions that a developer will impose on the assignment. And usually, these impositions make reference to a percentage of units sold. If a certain percentage of their units have sold, they will probably allow your assignment. And if they do allow it, there's also a time constraint. You can't assign it at any time. Usually it's a specific period of time, maybe 60 days, 30 days prior to interim closing, or something of that nature. Now, every agreement is different. Every builder is different. Everything is case by case. So please bear that in mind. Now, the assignor must also accept the fact that most builders, even if they give you a consent to assign, will not allow you to advertise, all right? So the exposure of your unit may be limited. So just bear that in mind. Lastly, you have to obtain the builder's consent, all right? You have to obtain the builder's consent, pay the builder's fees. You have to know who to contact, because oftentimes when it comes time for you to approach the builder to ask for consent, maybe that project has already finished and there's no more site office. So you have to know who to contact. Now, more and more I'm seeing a lot of builders. Remember I said the builders don't particularly like assignments? I'm seeing a lot of builders basically saying to purchasers, well, get your lawyer involved, okay? Have your lawyer write in. Have your lawyer request for the builder's assignments. So that's also very common these days. Just remind your clients that indeed they need to engage the services of a lawyer. That's what they have to do, all right? Through no fault of your own. Basically, that's the way your particular builder wants to deal with this assignment. All right, so what are the issues that you may have to face as the assignee? All right, now let's say your assignment closes before interim closing. Then we don't really have an issue, right? It hasn't been occupied. So the assignee, if he wishes to personally occupy the unit, not an issue. If he wishes to rent the unit, also not an issue. The assignee, if he wants to personally occupy, will qualify for the personal use rebate, okay, or the rental rebate, depending on what he or she intends to do with the unit. Now, the issue arises if the assignment closing date occurs after the interim closing. Now, sometimes the unit may be tenanted. So if there's a tenant in there, the new assignee is limited in what he or she can do. The new assignee must assume the tenant. Yeah? He or she must assume the tenant, notwithstanding the fact that perhaps they want to personally occupy. All right? So you can only personally occupy after the tenant vacates, and you have to give the proper notices and such under the Residential Tenancies Act. Now, the assignee will still qualify for the HST rebate, all right? And that HST rebate arises if the tenant has a one-year lease, and the HST rebate can be applied for after final closing. Now, unfortunately, even if the assignee wishes to personally occupy and get the personal use rebate, he can't. So that he can only rely on the rental rebate, which is basically about the same thing. If indeed there is a tenant, make sure as the agent you wish to look at the lease. You have to think about things like direction to pay future rents. You need a tenant's acknowledgement, and you need all of the tenant's info, all right? IDs, where they work, all of that. And also bear in mind that when the assignment closes, we have to account for or adjust for the rentals and the rental deposits and any interest payable. They all have to be adjusted. Now, when an assignment occurs after interim closing, just treat the transaction like a resale, all right? And that's because there's a physical unit, physical property that you can inspect. You will also have to consider occupancy fees to be adjusted. You need to review things like the interim statement of adjustments. Also put in warranties regarding the chattels, that they all should be in good working condition, notwithstanding the fact that they're brand new. Also request things like the instruction manuals and requests for holdbacks for realty taxes. And most importantly, if the unit is vacant, there's no tenant in there, and the assignee wishes to personally occupy, please ask for a declaration from the assignor that he or she has never occupied the unit, all right? Now, also ask for the Terrian inspection certificate and maybe even a final visit. So just treat it like a normal resale situation. Now, in terms of putting the assignment agreement together, some basics. Make sure you get the unit correct. Make sure you get the address correct. Make sure you get the levels correct. And make sure you know whether parking or locker spaces are included. Okay, these may seem minor, but nonetheless, they are important. Now, in putting together an assignment agreement, don't forget to put in conditions, all right? Number one condition, conditional upon obtaining builder's consent. You can't do any of this without the builder's consent. Now, in obtaining the builder's consent, oftentimes there are conditions to obtain the builder's consent, such as 25% of prepaid deposits, okay? It can be even as high as 35%. Now, if the original purchaser only paid 15 or 20, then you have to be aware that the assignee will have to make up the difference. Now, a lot of builders will also consider the financial ability of the assignee. The assignee may also have to obtain mortgage approval and give information under FinTrack. And lastly, the assignor will have to be responsible for the payment of all the assignment fees. Now, what's in a builder's consent? Okay? Please read it. Just read it once, and I think that should be good enough. Now, a builder's consent basically is a document provided by the builder confirming the amount of the deposits. That's really important because the deposits will have to be paid by the assignee on the assignment closing date. And basically, once the consent is signed, it's basically everyone's recognition of the new purchaser or the assignee. And thereafter, the builder will deal with the assignee unless there's a default. The deposits are automatically assigned to the assignee once the builder's consent has been signed. All right, so please bear that in mind. Once the builder's consent has been signed, all of the prepaid deposits paid by the original buyer will be assigned to the new assignee. Now, the only thing that I'm finding in builder's consents is that they will not tell you whether the original buyer has defaulted. So it's not really what we call an estoppel certificate. It doesn't really tell you whether the original buyer has any NSF charges for bounce checks or any interest paid on late payments. So that part we have to be mindful of too. Now, lastly, some builders have been canceling, capping, or certain incentives in the builder's consent. So therefore, that's why it's important to read it, even though it looks like the same document over and over again. Some builders have been known to make changes or amendments to capping charges in the original agreement. So if that occurs, your assignee has to know. All right. In terms of putting together a good assignment agreement, the other thing you have to consider is when is the assignment closing date? All right? There's a lot of confusion over this. When is the assignment closing date? Now, technically, the assignment closing date is the date when all of the conditions in the assignment agreement have been fulfilled and the date funds are payable to the assignor in accordance with the assignment agreement. Now, 9 times out of 10, the closing date is basically the date that all of the prepaid deposits are paid to the assignor. And after that date, the assignee will be recognized as the one true purchaser. And the assignee will be closing the transaction with the builder. Now, how do we determine what the closing date is? Well, it depends. It depends on who you represent. If you're acting for the assignor, all right, he's the guy that's selling. If you're acting for the assignor, you want everything up front, correct? You want the deposits, you want the profit, and you want it as early as possible. You don't want to wait around. You don't want to wait for another 2 or 3 months to receive the balance. Now, if you're acting for the assignor, I would suggest have an assignment closing date as close as possible to the date that the builder provides its consent. All right? For example, 2 days after builder providing consent, because if you wait any longer, all of the prepaid deposits technically have been assigned to the assignee. So the assignor doesn't want to be out that amount. So have the closing date as early as possible. Now, the flip side to that, if you're acting for the assignee, you want to pay out as long as possible. You don't want to give the assigner everything up front. Granted, you do have to pay the prepaid deposits up front, but the profit, you would probably want to pay in stages. And also with some sort of holdback, just in case the assignor has any penalties or interest that he hasn't paid. Now, don't forget, the builder, whatever charges that's payable by the assignor, he doesn't care who it's paid by. He's going to collect it from the assignee. All right? And since we don't really know whether there are any such charges that should have been paid by the original guy, we want some sort of holdback. Now, obviously, the assignor's lawyer is probably going to say no to that. All right? It's just a little bit extra work. And of course, no one wants to do anything more than they really need to. However, if you don't do that, I'm just going to tell you a real life situation. We had a case in our office where the assignee was stuck with a $1,500 NSF charge that belonged to the original assignor. All right? No one knew about that. It wasn't disclosed anywhere. It was not disclosed in the builder's consent, but it showed up on the final statement of adjustments. So you can imagine what a shock my client had when he was presented with the bill belonging to the original buyer. Now, we sort of had a okay ending to that. Luckily for us, the original buyer was still around, but he didn't have any money. So they worked out something, and the original buyer reimbursed my client, I think, half of the charges, and we're still negotiating for the balance. So these are real life situations that can occur. Now, some other conditions that you will need to put in your assignment agreement, and that's to protect the assignee. And the reason why you need a condition for someone to review the original agreement of purchase and sale, because in effect, that is what the assignee is assuming. He or she is assuming all of the rights and obligations of the original agreement. Now, what are we looking at when we review the original agreement of purchase and sale? There may be additional charges. For example, for levies, there may be additional charges for meter installations, sometimes for 2 months of common expenses, realty taxes, all sorts of goodies that's sprinkled in the agreement. And sometimes these charges can be quite substantial, as you are all aware. $10,000, maybe even more, is not unusual. You may even want to consider maybe splitting these charges between the assignor and assignee, depending on the price of the assignment. Now, also look out for things like restrictions and warning clauses in the original agreement of purchase and sale, such as any restrictions on pets. There may be some noise issues, there may be some vibration issues. All of these things which may impact the assignee purchasing this particular unit will be disclosed in the original agreement of purchase and sale. It's also a good idea to look at the declaration and budget information. Also be aware that maybe at this time with the assignment, the color selection and tile selections, everything's been selected and there may not be any changes allowed. So make sure the assignee can accept that. Now, lastly, also be aware that some credits that's in the original agreement may or may not be assigned to the assignee. All right? Some credits may be personal just to the original buyer. For example, as an incentive, sometimes builders will have a $5,000 credit for the first 50 buyers. And unbeknownst to the assignee, that $5,000 credit, he or she is not entitled to it because the fine print says the $5,000 credit is personal to the original buyer and cannot be assigned. All right. Now, assignee satisfactory financing. All right. This is one of the biggest issues that I'm facing in my law office with purchasers not being approved for financing, or they can't arrange mortgage at the last minute. So if indeed your assignee is purchasing on an assignment, make sure they can close on the final closing date. You may even want to put a condition for an inspection of the unit. And again, make sure you review, if the property is tenanted, make sure you review the tenant's lease and any other relevant information pertaining to the tenant. Now, lastly, obtain an HS2 ruling and obtain accounting advice. So this is going to come later, but it's fitting to put it as a condition. All right. Now we're going to be focusing on the HST implications of an assignment agreement. Believe it or not, CRA wants a piece of the action. They are now cracking down on all assignment transactions. And CRA is actively pursuing the payment of HST on assignments. And not just the HST. They're also pursuing capital gains and perhaps income taxes payable on that transaction. Now, some of you may say, well, I've never heard of this before. What are you talking about, HST on the transaction? Why now? You know, like, is this new? Well, I guess it's always been around, but it's new to the extent that CRA is finally catching up, all right? They didn't really have a tool or vehicle to track who was assigning their assignment agreements, but now they do. CRA basically is tracking who has been assigning their contracts via the deposits, okay? So the original buyer, when they put down a deposit for the original agreement of purchase and sale, they have to do it in compliance with FinTrack, okay? Your name, your social insurance number, everything's associated with that deposit. And a few years later, when another individual closes this transaction, CRA knows something's up, and that's when they will start looking, all right? Now, what is CRA looking for, all right? They basically want to determine whether the assignor is considered a builder for HST purposes, and whether this transaction amounts to what they call a taxable supply. Okay? If they can establish that, then indeed HST is payable. Now, they also want HST on the return of the deposit, okay? A lot of folks think, why are they charging HST? It's just the return of my deposit. No, not so. It's not considered a return of the deposit. It's considered a taxable supply, and HST is payable. Now, CRA, in order to make that determination, they will examine the intention of the buyer and the reasons for why you are selling your contract. Everything is case by case, case by case. CRA will rule. Unfortunately, in the majority of the cases, they will rule that the assignor is a builder, okay? Unless the purchaser, the original purchaser, can establish that there has been a reasonable change in circumstances, all right? Now, what is CRA looking at? When you originally purchase the unit, if your original intention was for, of course, personal use, or for a child to attend a university, or a wedding gift to your son or daughter, you want to be closer to work, maybe you're downsizing, maybe you want to buy the unit for an elderly parent, or even a part of a separation arrangement, okay? Now, CRA will conclude HST will not be payable if you can show what they call a frustrated intent. A frustrated intent. Now, if your son or daughter did not get into university or they decided not to attend, that may be reasonable. Let's say your son or daughter did not get married. Yeah, that's reasonable. Let's say your workplace changed or you lost your job. That's reasonable. Maybe you decided not to downsize. Yes. Maybe your mom or dad passed away or they're in a nursing home now, so no need for this smaller unit. Or the couple made up and they're no longer separating, so they don't need another place for the wife or the husband. Now, if those circumstances are considered a frustrated intent, then CRA may say, that's okay, you don't need to pay the HST, all right? However, if CRA determines that this is a purely an economic exercise or opportunity, then no, then they will deem the transaction HSTable, okay? And some of the indicia of the economic reasons for the sale may include the fact that the original buyer purchased multiple units. Let's say he bought like 3 or 4 units in this building and 4 or 5 in another building. Yeah, that doesn't really prove that he purchased the units for personal use. Or the purchaser is put in the name of a corporate entity, all right? Or the use of the unit is not supported by the individual's lifestyle. So for example, if the original buyer says, well, I've decided to move downtown. I live in Markham. But on a closer examination, he has a family, he has 3 kids, and he lives in a 3,000 square foot home in Markham. So how likely is he going to be downsizing to that extent? All right? Probably not. Now, let's take a look at how the HST is payable, or on what amounts the HST is payable on. Basically, three things. Number 1, it's payable on the gain. Let's say the gain's $100,000. It's also payable on the return of the deposit, which they consider a taxable supply. Let's say it's $80,000, and also the cost of obtaining the builder's consent. Let's say it's $5,000. So all of these figures added together, $185,000 times 13%, we have a $24,000 HST liability. Now, who pays for the HST? Okay, in reality, no one wants to pay for it, right? Legally, the assignor is at risk. The assignor is the one that's exposed. Now, if indeed the assignor is a non-resident, all right, this is why you need residency of the assignor. If he or she is a non-resident, the ultimate responsibility to pay falls on the assignee. All right, so be careful. So let's say the assignor takes off with all of his funds and he goes back to Peru, and CRA can't find him to pay the HST, then they'll go after the assignee. So just be aware of that. In an ideal situation, again, I'm talking about ideal, the assignor should obtain an undertaking from the assignor or the assignor's lawyer to pay the HST and an indemnity to indemnify the assignee if indeed he or she is stuck with paying the HST. Now, sometimes you can't determine who pays, all right? And if that's the case, consider a holdback. Do a rough calculation of what you think the HST should be and hold it back until a determination. Now, I mentioned that in reality, no one wants to pay the HST, all right? However, the HST can be negotiated between the assigner and the assignee. Now, paragraph 6 of your standard AREA form talks about whether the HST is included or in addition to, all right? Now, if you don't pay attention to this clause and you just let it go in the usual course, if it says it's included, who pays? The assigner pays, exactly. If it's negotiated by saying in addition to, who pays? The assignee pays, all right? So everything is negotiable. All depends on the assignment price. Now, I mentioned about obtaining an HST ruling. I think that's really important. Now, the only downside with obtaining an HST ruling is that it takes forever for CRA to give a ruling. They told me that to get a ruling, a written ruling, will take them 45 days, or maybe more. They said maybe less, but I doubt it. So you're looking at 45 days, and the reason why they need this much time is because they have to establish intent. So they have to do their own investigations. So what I'm saying here then is, if you have an assignment agreement on your plate, especially if you're acting for the assignor, you may have to take extra time to determine whether the assignor will be liable to pay HST or not. Now, when you do pay the HST, it's via the GST form 62, and basically, in order to avoid the payment of penalties and interest, whoever is responsible to pay for the HST must remit it 30 days after the last day of the month of closing, okay? So anything later than that, you'll be docked penalties and interest. All right, now, a lot of builders provide a free assignment to a close relative, correct? You can assign to your son or your daughter. I'm just going to warn you, tax implications also apply to these particular transactions. And you cannot just use a direction retitle to add your son or daughter on title. You must do it via an amendment of the agreement of purchase and sale or through an assignment. Now, we can query whether HST is payable if you can establish that there's the intent that it was originally purchased for your son and daughter, then HST may not be payable, all right? However, over a period of time, most condos have increased in value. Now, you can't just gift that increase in value to your son or daughter. There's a tax consequence associated with your assignment of the increase in value, even though you did not receive a penny from your son or daughter. So please keep that in mind also. All right, now, the assignor. When he makes his $100,000, everyone is so happy, especially the assignor. However, it doesn't stop there. There are tax consequences with respect to his $100,000 profit. If it's established that this individual is not in the business of flipping homes, then the $100,000 will be treated as a capital gain. So a capital gain, only half of the gain, less all of the eligible deductions are included and taxed at the payer's marginal tax rate. Now, if it's determined by CRA that this individual operates or excuse me, or is in the business of flipping homes, let's say there's a pattern over the years. The last 4 years, this chap has flipped 10 homes. Then CRA may come down relatively hard and say to him, no, it's not capital gains. This is considered business income. All right. So all gains must be reported to CRA. All right. Now, knowing these tax consequences, here are the few conclusions that I propose that you be aware of and be mindful of. The fact that CRA is now focusing on the recovery of HST, they're chasing after capital gains and even business income. The shift in focus for everyone now should be on the HST implications of an assignment agreement. You need to involve your accountant as early as possible. Involve CRA. If it's necessary, please obtain a ruling. Do the math. Do the math. It may be cheaper to close than to sell on an assignment. Okay. Some of the other issues, real estate commission, when is that paid? Usually on the assignment closing date and not on the final closing date with the builder. Now, also be mindful of the payment of land transfer tax. It's not paid on the original purchase price. It's paid on the assignment price. And be mindful of Toronto's land transfer tax, which is double. Okay. Now, Schedule B. Schedule B. This sets out all of the numbers in your assignment transaction. And from looking at my slide, basically it's a scenario of your total purchase price, the purchase price of the original agreement of purchase and sale, the amount of the deposits, and I want to ask you to see whether you can figure out what number 4 should be, if you can see it, all right? If you can't, that's fine. If you can't, that's fine. For those who can figure it out, try to see whether you can do the math. And then also, the other figure that trips up a lot of agents is the last one, the balance of the payment of this assignment agreement. So, we're just going to flip over and basically tell you the answers. So, 4 is basically $122,700, and I show you underneath how that's calculated. Now, don't worry too much whether you get the particulars right now. If you leave your business card with us today, I will email you my complete slides, all right? So don't worry about it. Don't worry, you're sitting at the back and you can't take a picture of it. So don't worry. I should have mentioned that initially. I'm going to do it for the next one, all right? All right. So then you can look at it through your leisure, and if you have any questions, feel free to give me or my colleague, Mr. Ernest Wu, a call. We will be happy to answer your questions. Now, before I finish, we're almost there. I'm just going to give you one other scary thing, all right? I don't want to scare you, but it's a bonus because this has happened to a colleague of mine, and he was generous enough to share it with me. Oh, sorry. I'm just going to flip back a little. Sorry. For that particular scenario, I just wanted to show you how much HST is payable on that particular transaction. It's approximately $36,800, quite substantial, all right? So don't think, Mr. Wong is going home with all of his profits. He's not. So be aware, be prepared. Now, the last thing, okay, the last scary thing with CRA, they're really coming down hard, aren't they? Anyways, I guess that's their job. Now, a colleague of mine basically told me, he said, hey, Shirley, I had a client who closed a transaction in 2013. He rented it. He just received an audit notice from CRA. They're auditing his rental rebate application, all right? So not only are they auditing personal use rebate applications, they're auditing the rental ones. So if your client is renting, please remind them to keep an original agreement of purchase and sale, keep their statement of adjustments, have them keep an insurance policy or binder showing that the unit has been rented, keep a copy of the lease, proof of rental payments in the form of canceled checks or payments into your bank account, all right? And lastly, proof that the property manager was aware that the unit was tenanted. So be aware, be prepared. All right, thank you very much for attending.